other similar elements of electronic evidence. So after spending this next hour with us, please do go check that out as well on YouTube if you want to perhaps have a slightly broader outlook into what is happening here. Our conversation today is fairly limited to just this phenomenon of police stopping people at random to check their phones. As you know, of course, IFF is committed to working on digital rights in India and making the law and rights and legal procedure accessible to everyone. And as a publicly funded organization, your support is what keeps us going and enables us to do this work. So if you would like for us to be able to continue doing these sort of events, please do consider donating to us at internetfreedom.in/donate. And once again, that's internetfreedom.in/donate. So anyway, now to skip on to the interesting part, which is first the conversation with Tara and Jeevika itself. Tara is a litigating lawyer based out of Delhi. She has a diverse practice with a focus on defense litigation in cases that involve the abrogation of civil rights as well as broad-based criminal defense. And she's represented a number of clients against cases under special laws such as the Prevention of Money Laundering Act, NDPS offenses, and UAPA. Tara also has a keen interest in child protection laws and has worked extensively with minor victims of sexual assault. Our other speaker for the day, Jeevika, is a feminist social worker and lawyer. She has also extensively worked on issues of public policy, gender justice, legal aid, governance, and systems of criminal justice. She's a rights and justice advocate and a member of several networks across the country to this end. She is also currently a national gender youth advocate nominated to UN Women from India to further gender equality in particular. So thank you so much for joining us today, Tara and Jeevika. I'll just head on directly to the questions so that everybody can have maximum time to hear from you guys. So Tara, this one is for you, and Jeevika, of course, please feel free to pitch in at any point and add on. And I'm sure both of you, both your perspectives will be unique and could benefit from each other. And I'm certainly excited to hear what both of you have to say on all of this. So Tara, first question is, what powers of search do the police have if, I've not even been detained or arrested? And how does this sort of interact with my right to privacy?
So I suppose from everything that I've read and tried to read, the jury is still out. Firstly, by the way, I have to apologize to everyone. I have a cold, which is just starting to act up. So I apologize for any sneezes and unseemly noises that may interrupt our conversation. But back to the more important question at hand. I think the jury is out on this one. But I think what is worth remembering is that the police only have to give a reason, and that can be any reason. Technically, they don't have any right to stop a random person on the street and say, like they were doing in Hyderabad and in Bangalore, and say, oh, give me your phone. I'm going to do a roving and fishing inquiry. The CRPC is very clear that any document or thing can be produced if it is considered necessary or desirable for the purpose of investigation, inquiry, trial, or other proceedings. That's Section 91 CRPC for anyone who wants to look it up. And 93 CRPC confers a power on a court to issue a search warrant. And that warrant is, of course, limited, probably way more limited than any inquiry by the police. Then there is also a power. The police also have a power to search any place. And in case of emergent circumstances, they can search closed spaces. And Section 100 CRPC puts an obligation on them, the persons residing and in charge of such places to oblige the police to comply with their directions and to cooperate. So that is problematic because recently some law has come from Karnataka, which suggests that a mobile phone is like a place. If it is to be used or to be looked into in a routine or planned investigation, that would require a prior warrant. So to that extent, it's a good safeguard. But if there is an emergent circumstance, then relying on the same law, the police could go ahead and look at your phone. But there has to be an emergent circumstance. You have to either be a witness, or there has to be an incident adjacent to seizing the phone, or you have to be an accused, so on and so forth, for the police to be able to stop you in this manner, which from the incidents in Hyderabad and Bangalore, there was no such circumstance. And I would say that it is wholly illegal to stop somebody in that way.
Okay, so just for anybody who might not know this, the CRPC is basically the Code of Criminal Procedure, which governs how criminal procedure is sort of carried out in this country, and includes the powers and obligations, etc., of the police, the judiciary, just law enforcement at large with respect to criminal law. Also, Tara, if you'd like to, sort of speak a bit about the right to privacy and this sort of police randomly stopping and doing, searching people's phones or asking to see their photographs, whatever it might be. Or Jeevika, if you'd like to step in and perhaps.
Yeah, I'll just say one thing and then I'll let Jeevika step in, because I think on the right to privacy, she would have more to say. But basically, the right of privacy is not absolute, that we know from Puttaswamy. It is a justifiable, circumstance for police to, it's basically related to crime prevention and police investigation, and that is a justifiable circumstance in which the right to privacy can be abrogated from. But I don't think that random searches of persons not otherwise involved in any incident would pass that test of lawful abrogation from the right to privacy under K. Puttaswamy. I'll turn it over to Jeevika.
Yeah, I just wanted to go back to the first question first before we even, move to the right to privacy, because I think there's so much involved in just, this whole concept of procedure of investigation, as Tara said. So just adding to it in terms of, what you can search, what today counts as a search in a digital world, an ad hoc search. And then within that, there are so many layers of the law beyond CRPC when you're talking about preventive detention, when you're talking about communities and areas, the whole question of which areas are being searched, which has come up in Hyderabad. It's been in the complaint as well. I know that Internet Freedom Foundation supported Srinivas to push that complaint. And there have been other citizens who've also filed these complaints, including affected parties directly. So I think that whole question of, what is the due process in this? And then, the right to privacy sort of adds to it, because it assumes that you're going to not assume that everyone is a criminal, right? And the minute you start doing these sort of searches, you're flipping that assumption in itself. So I think that problematic bit, because of course, it's not absolute, but still the criminality assumption, that the right to privacy can now be moved away, saying, and to the presumption of criminality instead of the presumption of privacy, is a scary bit in these procedures itself, right? And I think without sort of unpacking what that means and what provision, we're just going to be looking at, this whole challenge of people sort of, at least those who know, asking some questions, otherwise just sort of giving in into this process itself. And I think this whole question of the phone as a place, right? Like, even when you have a place, you have set procedures of how you, as Tara said, 191, there's 193, there's so many others. So even if you treat the phone as a place, it's so different. And when you are doing it in public spaces not sort of, bereft of where you are and who you are and, what spaces are these searches being done in. And it is anecdotal evidence, right? But it is evidence to communities who've been saying this. Perhaps it's come into urban areas, and it's come into the streets, and it's, of course, in current socio-political times, it's a bigger challenge. But I think some communities have faced this for a while and have been speaking about it. There have been, like the denotified or the criminal communities who were earlier counted as criminal and then decriminalized. But we have seen random searches, and now we are seeing even the digital world of these communities being searched even more. And of course, there's not enough data on it, but there is anecdotal evidence which shows that these are communities, and some studies around where police has been doing these sort of searches, including Criminal Justice and Police Accountability Project, communities themselves, like the Tara community, and I know Dakshin and others have given statements from the community, so we have to look at it in that context of, investigation itself is also.
Yeah, definitely. I mean, I think these broader questions are also extremely important to look at. And I'm glad that this conversation is giving us the opportunity to do that, in addition to sort of enabling non-lawyers and people who are outside this world of understanding perhaps what is or isn't in the law to actually get a sense of how is one supposed to conduct oneself in public space when this sort of increased fear for certain kind of policing is emergent and there right now. And so, in that context, I'd sort of like to skip back to kind of talking about, these specific instances of what have been happening. And so, for instance, if I'm just sort of, and this is honestly a question that's, that these sort of questions come to all of us, I'm sure, often as lawyers, from our friends and just, you're out somewhere at a party, or you just have friends who are not lawyers who are constantly asking me these questions of, okay, what do I do if I'm just sort of going about my business, walking around somewhere, and the police come up to me and ask to check my phone? In this situation, can I say no? How do I say no? How do I go about navigating this situation? So perhaps you can go back to Tara again to speak about this a little bit. And of course, come back to Kenji.
I think it's my legal opinion, and it may be wrong, and it may be held wrong in the future. I just want to flag that because everything is in flux in terms of the law around this right now. But it is my legal opinion that you can say no. That you can say, sorry, go to hell, I'm not giving you my phone. I'm not even stopping. Tell me why you have stopped my motorcycle or me walking down the path or whatever. First, tell me why you've stopped me, and then tell me why you need my phone. And if there is suspicion of it being involved in a crime or having committed a crime, even then, I think that while seizure is something that they may not be able to prevent, I still think the jury is out on the giving of a passcode and so on. There is, again, law contrary to what I'm advising here in Karnataka. It is not so settled in the rest of the country. Karnataka, that decision of Karnataka High Court, though, will apply across the country until something else comes about. So what I am the import of my advice would be, take a chance on it. I mean, that's what I would say. But I think that there are, let's look at it from a slightly different angle. What happens if you don't give your phone? Of course, the obvious is you could be subject to police harassment, which is outside the contours of law. There's really nothing one can do about that, in the sense that you can try to record it, you can have it recorded somewhere, and you can see how far the police really will go. Are they going to rough you up? Are they going to take you in custody? What's going to happen? There are two provisions which would apply if the police try to make out an offense against a bystander or a passerby. There are two provisions from the Indian Penal Code which could be invoked. One is it's breach of an obligation, essentially, to assist a public servant when bound by law to give assistance. So if any person is bound by law to give or furnish assistance to any public servant while that public servant is doing his public duty. So for instance, a traffic cop can stop you not only because of a special provision in the Motor Vehicles Act, but also because of this. It makes it compulsory for you to comply with being stopped because of Section 187 Indian Penal Code. So failure to assist a public servant in this regard, that could be one thing brought against you. But you have to be bound by law to render or furnish assistance. So while the Motor Vehicles Act binds a person to stop if asked to stop on suspicion of a traffic violation, that's not the same for a phone. You're not bound by law to just stop randomly without having done anything if a police officer stops you. The second is refusing to answer any public servant who's authorized to question you. So there are two limbs, once again, to this. One is, are you legally bound to answer in a situation like this? And the second, is the public servant authorized to question you in this manner as regards your phone? as regards the search and seizure of the phone? And I would say not. I think neither Section 179 nor Section 187 would really be applicable. But again, as I'm saying this, I have to warn that the law is still in flux in this regard. And most likely anybody who refuses will be harassed in some manner or will have to face some sort of something. I leave it to everyone's imagination what that may be.
Yeah, I think this was a question that, I mean, a lot of people do have, and that a lot of people sent in to us, around sort of how to navigate this situation where you may not want to show the police your phone, irrespective of, whatever information you might have on it. If you have some information that is not illegal, but that you just don't want them to see because it's your phone and it's your private property and you're entitled to that, then how do you kind of navigate this situation without getting into further trouble with the police? Is there a way at all to do this? And I feel like you have addressed that to some extent, or to a large extent, actually, just talking about how to navigate this situation. But Jivika, also, if at all you have anything further to add on.
I think the critical question is to ask for the due process, but to ask it in a manner that you're not inducing further harm on yourself, right? Like, and I think that's the critical sort of negotiation. The law, while it's clear in Karnataka and applies to the rest of the country, still leaves ambiguity around how you can ask for these things. And I think we must continue to use that. To ask for what was your due process, what did you document in writing, even if not then what is it of this search that you can get in writing to be able to ask for more answers. And I think that's the critical bit that even lawyers have been pushing, whether in Bangalore or in Hyderabad as well, to say, let's look at what's coming out in writing, especially since the police can use 165 to say, give reasonable reasons. So even if they do it, and then you question on, was this doing it later? When did you do it? Was that procedurally correct? So I think that's one way to go about it. But just again, all of this is safety opinions and not legal opinions standing the court of law. How do you cooperate? Because there's so much more around cooperation in investigations. And then ask the question of, was there an investigation which had a due process which was followed, right? Because you are looking at people who are vulnerable in a situation of power. And how do you, and you are more vulnerable because, these are serious offenses which are now being levied, whether it's under NDPS or we're seeing other charges as well. And it's just a matter of speculation where this can sort of go to. And we have seen, it go to some, targeted communities in other spaces of violation of procedural rights. So given that reality, I really think we should be asking for 2-3 things the minute you do get, if you're randomly stopped. And this of course goes to random stops, and it does not apply to when you have a search warrant and what you should do with your phone.
Yeah,
like Mala said in the beginning, that's a completely different conversation. When you're part of an investigation, please don't try any of this at that point. Get in touch with your lawyer at that point. And I think that's, very, very clear and settled. But in this one, at what point can you negotiate? What can you ask for in terms of, if they do have something in writing, ask for it, even if it's for a general search. Have they done some procedural work for the general search? Just asking the question politely also hold some sort of accountability. Of course, if you're alone, it gets problematic. But if you are able to sort of, do that even later. But the thing is to also do it later and not jump into a situation trying to be an activist in your own cause, first figure out the law before you try and turn into an activist. But also procedurally asking for it in writing, making sure that you're asking if it was recorded, if it's even general procedure under 165 and not, the search warrants and all of that, and what it led to. But also, knowing that there are some things preventively on phones that one needs to now keep as digital cleanliness, making sure, and these are just things that safeguard, as we say, in the world of knowing your own criminal justice rights. So I would work on that side as well, because we do see this is something that can be used for targeted harassment. And at that point of time, I mean, there are few who are lucky, but if you know that you can call a lawyer and there is that space to ask these questions, even if you don't know them. But asking for something in writing, following up the complaint, and making sure that you don't assume that this is okay in the past, because it's not okay. As Tara said, it is still not, if you ask me, it's just wrong to do this, given that there is the right to privacy and there is the right to not assuming that someone is a criminal, and you can't just investigate without reasonable presumption of someone being accused of.
Yeah. Can I just add one thing?
Please do.
So the other thing to consider perhaps when you're making the decision of whether to cooperate or not is to understand the consequences either way. Non-cooperation means they could haul you up for 187 or if it's an out of the blue situation. That's the only sort of situation which I'm addressing. If it is an out of the blue kind of situation, there's a 187 and 179, which I mentioned. If it is in the course of an investigation, or if it is adjacent to an incident, or if you're an accused, if you give the password, there's no fruit of the poisonous tree doctrine as such in India. So the seizure would not per se be illegal. You have a right against self-incrimination, but Karnataka High Court has already held that giving a passcode does not amount to infringement of that right. I don't agree. Without a doubt, I don't agree. And I hope somebody challenges it. Maybe a challenge is already pending in Delhi, I think, if I'm not wrong. So that may change. But basically the call that one has to take is if the information in the phone is more damaging, or the consequences of not giving that passcode is more damaging. And given the right against self-incrimination, which is, by the way, only applicable if you are an accused. It's not applicable if you are randomly stopped by the wayside. So it's a funny kind of thing where if you're an accused, you can still probably say that this would be violative of my right of self-incrimination, but you can't if you're a bystander. So anything that the police potentially recover from you by force, or if they send it to FSL, and that's forensics, and the forensic lab manages to open your phone or your apps, etc., that could still be used against you. It doesn't outlaw such a search or a seizure if it is per se illegal at the beginning. So that's something to think about for anyone who's facing this kind of conundrum as well.
Thanks, Tara. Thanks a lot for that. And Jivika as well. One thing that, when I was looking at these news reports and trying to see what it would be interesting for us to talk about, what has been the, lay of the land in terms of this happening. So every time, there's been a report about this, and the journalist who's writing it has reached out to a senior police officer to ask about this incident that's happened, or a series of incidents that are happening. The police officers are always sort of saying, no, we don't check people's phones without their consent. They only give it to us voluntarily. The Hyderabad Deputy Commissioner of Police had said this. Even with respect to what was happening in Gujarat, the police had said, that no, we thought that we suspected some people. We started this phone combing drive. We thought that we found certain people seeming suspicious to us. And then, when we asked them if they could see their phone or if they had this information, they voluntarily handed over their phone. So what do you, have to say about this? What do you think about this?
Well, I think it's garbage. I don't think there's any such thing as free consent when you are confronted by a police officer saying, "Hey, phone dikhao." Matlab, what are you supposed to say in that circumstance? The only way to enforce something like to enforce any kind of procedural certainty and also safeguards is to flat out make it illegal to do this. And I don't see why not. It's fundamentally, I think it's a problem with how we also conceptualize technology perhaps in this country, perhaps in this judiciary, I don't know. But technology, in my opinion, is an extension of the self to a large extent. And this is popular feminist theory that I'm kind of basing my thought off. It's not something that I've just come up with. It is an extension of the self, and therefore the right to privacy should extend to, say, your device. And it really, and this has been noted across judgments, that smartphones are more than just a document that you're keeping in your house or in your drawer. It is your life. It is your entire person out there in a device. So if that is the case, it should just not be permissible for anybody to rove and search through a device without a specific warrant as to what they're looking for. And so you cannot, in my opinion, read consent into the handing over of a passcode or a phone or whatever. I think consent has no role to play. I think it should be treated the same way as disclosure statements are treated. So where if a person is in police custody and they give a statement, that statement can't be relied on in a court of law as evidence. And I think it should be treated a similar way.
Absolutely. I think just the fact that you were talking about consent in front of a police officer, instead of talking about your rights in front of a police officer and, what you can say and what disclosure means, I think we need to move the conversation back to the powers of the police and the disclosure argument. And we have seen, like the police in Bangalore has said that we suspend any such drive to do such searches when they were questioned. So which also shows you, when held to account, we are going back to, the unsaid thing of no, it's not consent. So, how does this get done when there is no clear rules, and yet we are seeing suspensions of such drives when there are questions asked by citizens, right? And I think that's the bit that we also need to focus on. If it was so clear, officers would be standing up and sort of saying it instead of saying the word, we are not doing all of this. And I think consent used like this is completely misused. As Tara said, the word garbage, I think appropriately said, and it needs to be sort of questioned, because if you're not going to do it now, you're going to set precedents in so many other states. But also being mindful that this is a conversation that we're having of people who perhaps have that power to even negotiate, right? Like, the question of consent comes when there's a power to negotiate. And we do see this in someone, you brought this up right at the beginning, being very mindful of things like AFPA, which give you differential, investigative rights, differential search rights, differential ways of sort of, governing literally communities and criminal justice and bringing them into the everyday, or even spaces where there is, it's used very easily when you are talking about communities who've been ghettoized and criminalized. And how do we then talk about this, where the power equation is even more, like there's such a big gap in the power equation, and we need to continue to talk about disclosure in front of a police officer, whether it's, after investigation or in the random searches. So I think the disclosure and random searches is the sort of even technical words we should be using, given that the phone has everything. And I think even within that, we need to start breaking down digitalization into what is possible instead of the phone as a monolith, right? Like, I think that conversation across that what all can be searched, what all can't, how do you then navigate it? And also the thing of how much in front of whom it's being done, right? Who are you allowed to take when you're doing, when there's a random search? What are the rights before the search begins? When you're stopped, between stop and search. I think these are some critical questions we need to start nuancing even further in the whole debate.
Thanks, Jivika. Thank you so much for that. And thanks, Tara, as well. I feel like, you guys have put it across really well, and perhaps much better than I would have been able to even configure a question around this. I feel like we've covered such a universal things in sort of the answers that you've given us so far. And I just had one sort of last question before we move to maybe taking one question from a person who has asked on the YouTube live stream, which is that, Tara, you had mentioned, and Jivika, you had also mentioned this sort of right to privacy, and this being an extension of, the phone being an extension of your private self, and therefore you having certain entitlements over it, etc. So what do you think could be, or what is the legal basis for what is happening right now with the police stopping people to check phones post the judgment of the Supreme Court of India in Puttaswamy versus Union of India? Even if, in a situation where the police are saying, oh, this phone has been voluntarily given, and the person has not been able to negotiate that in that particular situation.
Jivika, why don't you go first?
Yeah, let me go. Let me try and, as Tara said, the right to privacy is not absolute, but it's there, right? The presumption of, there is a presumption of the right to privacy at least. And, making sure that you are looking at mobile phones. I mean, when you're looking at mobile phones, it is a violation of that erosion. And I think the Puttaswamy judgment clearly says that it needs to be reasonable reason, right? And none of this is in the realm of reasonableness, especially when you're talking about random searches in itself. And, when you're looking at people's intimate details, where, the whole, I mean, it surprises me and flummoxes me that we're still having to debate the right to privacy after Puttaswamy at such a point of time. And it's something that's been written again and again in all the complaints to the police, right? Across the board, when there have been complaints or questions and letters after these instances, that's the main bit. And it is a blatant, for me, it's a blatant violation of the right to life and liberty and privacy in that sense. But given that, where does the right to privacy sort of, work with the presumption of criminality, which seems to have taken over, as we said earlier, which is a bit that still needs to sort of be unpacked beyond Karnataka and, and all the contestations that are happening in the courts of law as well. And I think we need to also look at data and evidence of what's actually happening on the ground, and, people who have been searched to actually look at the contours of privacy as laid down in Puttaswamy as well.
Yeah, that's really interesting input. Thanks so much, Jivika.
Tara, do you wanna-
Yeah, if you have anything you'd want to add, please do.
No, only just springboarding from Jivika's last thought. I recalled that the letter by Srinivas in Hyderabad, it was Hyderabad, right? Yeah. In relation to Hyderabad. I recall that he said that the areas where the police chose to station themselves were he suggested that they were lower income areas, and that people may not be as equipped to refuse or to answer to the police when they were stopped. And it occurs to me that privacy for donkey's years has been the privilege of few, and the underprivileged underprivileged persons don't have privacy, don't experience privacy the same way that we do. And perhaps that extends to phones where, where we could fight tooth and nail, probably us and many of the people joined in this conversation. But really it comes down to what is the value and what is the value of privacy to sort of the janta, and it's a sobering thought, because we can have this discussion and maybe some academics or, students, etc., would benefit from it. But will it really stop this random search business? Are we the tribe that are affected by it the most? Yeah.
Amala, just to add to it, I think this whole thing of random, I'm going to question that as well, right? Because we do know that there's some method to the randomness. And that method is the method of how criminality functions in general. And I think this is the social worker in me, having lived in a community which was criminalized for 2 years. It was a denotified community. How criminality played out was not random, and how it played out in different searches. Every time there was a crime in the area, there were searches. This is just a digital extension of that. And so if we don't start talking about these, especially for, I can talk about denotified communities. You started seeing it with tribal communities, with Muslim communities, just bearing the cat. Within that, the most marginalized, who don't have the money, who don't have the resources. So, or the access to legal, provisioning. And of course, I mean, not legal aid as it's in the letter of the law, but just in the spirit of the law. Legal support. And I think that's the question we need to start perhaps asking, what does criminality mean and what does randomness mean? Because to me, it's not random. It's, having lived in Delhi and then having lived there, there's this, there is some systemic sort of assumptions of criminality instead of assumptions of, privacy or even liberty or the right to life, 2021, all of that.
I mean, if prejudice, oppression, bias are systemic, then so is this, let's just say.
Yeah, thank you so much, guys. Just because we're running a bit short of time, and I would like us to have the opportunity to very briefly answer one question that we've received on the YouTube comment section. And I think this is something that's come up in different contexts as well over the last couple of years. which is, so the question was, what if policemen are intimidating me and I try to reason with them, telling them about my rights, and they hit me and force me to unlock my phone? So then what can I do? I feel like you've answered this already, but I feel like, I mean, if there's anything else that you'd like to add.
Tara, take this one.
Well, it's a really tough one, because I would like to know, for instance, if it is has this person been summoned to the police station and they're being intimidated, or have they been stopped on the road? Have they been called as a witness or as a potential accused? The answer differs. But you can refuse if you can withstand the force, I suppose. And if you cannot refuse, then you have to comply in the moment, I suppose, and then take legal recourse later, which would once again depend very much on whether you're an accused, a witness, or a bystander, or a passerby. So it's very tough to answer it to that extent,
Yeah.
And anyone who gives you a generic answer, I would worry, right? Because this is really circumstantial and you are negotiating a power dynamic which differs in all of this. So if you are getting generic answers to any of this, please reach out to someone who's sort of dealing with the, the said and the unsaid of the law, and, what is still not clear in the law. And I think anyone who tells you it's clear, please question them as well.
Yeah. Yeah, thank you so much for that. I feel like, what you guys said earlier as well about having to navigate that particular context, and perhaps each context, even for each person, being markedly different from the other. I think all of that is sort of really important to remember and very interesting. I think we're done with our questions from our audience on the YouTube live stream, and we're also kind of running short of time. So yeah, perhaps we can, Shivani, if you want, we can sort of end the live stream.
Yep, I will